Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Danisyah binti Azmi and my matric number is 061244. Today, I will be explaining on regard to the case review, and the case that I have selected is AHMAD JALIL and public prosecutor. First, facts of the case. On 10 October 2012, a complainant, namely Said Bukhari, who served as Media Center Officer, Johor Contingent Police Headquarters, monitoring all activities on Facebook. He was being informed by his members that there was a message in Mauriddin Zakaria's Facebook inbox that his status was like insulting the Sultan of Johor, which was linked to Zuliyahia. He later checked Mauriddin Zakaria's Facebook through the Johor police account and found a message on behalf of Mauriddin Zakaria and an attachment link to Zuliyahia Facebook. Later, he opened a Facebook with the profile name Zuliyahia through the Johor police account. The words appeared were Sultan of Johor is white, like pig skin. Then, Said Bukhari has created a print screen and handed over to case investigating officer, namely Inspector Bachelor, and lodged a police report on 10 October 2012 at 7:44 p.m. The Communications and Multimedia Commission (MCMC), which monitored the commands, had sent by the Facebook account Zuliyahia and provided details relating to the Zuliyahia Facebook account to the Johor Police, including IP address, MAC address, and IP address users. The Royal Malaysian Police Forensic Authority (PDRM), which conducted an inspection at the IP address users' premises, found that a computer with internet history browsing the Facebook page Zuliyahia MAC address on the router is similar to the one given by MCMC. The computer then has been confiscated for further analysis. So now, we move to the part of issue. There are 4 issues related to this case. The first is whether the information on the command, IP address, and time of the command was met is challenged. Second, whether the testimony of expert witnesses has been challenged. The third one is whether other persons have access to the appellant's computer. The fourth one is whether Section 114A of the Evidence Act 1950 may apply. So now, we move on to the part of judgment. So the law applied within the judgment of this case is Section 233 Clause 1 Clause A and Section 233 Clause 3 of the Communications and Multimedia Act 1998. And then Section 51A Clause 4, Section 51A Clause 5, and Section 90 of Criminal Procedure Code. And Section 4 Clause 1 and Section 8, Section 90A, Section 103, and Section 114A Clause 1 and Clause 3, and also Section 132 of Evidence Act 1950. On 8 November 2012, the appellant was charged at the Criminal Sessions Court, Johor Bahru, Johor for 2 charges under Section 233 Clause 1 Clause A of the Communications and Multimedia Act 1998, which is also punishable under Section 233 Clause 3 of the same Act. On the 5th February 2013, the two above cases were requested by the prosecution to be tried together, and it was allowed by the Criminal Sessions Court of Johor Bahru. The prosecution has called 30 witnesses, all to testify and swear. On 14 April 2013, in connection with one case, the appellant was discharged and released, but in connection with other case, he was called to defend himself in the end of the prosecution case. The prosecution has filed an appeal against the decision to release and acquit the appellant. However, the prosecution's appeal was later withdrawn. On 21 October 2013, the judge of the Criminal Sessions Court convicted the appellant with an offence under Section 233 Clause 1 Clause A of the Communications and Multimedia Act 1998 relating to other case, and imposed a fine of 20,000 ringgit, and if he fails to pay, he faces 6 months imprisonment as provided under Section 233 Clause 3 of the same Act. The appellant appealed against the conviction and sentence for the judge. The court rejects the appellant's appeal against the conviction under Section 233 Clause 1 Clause A of the Communications and Multimedia Act 1998, and his sentence is a fine of 20,000 ringgit if he fails to pay him 6 months imprisonment as provided for under Section 233 Clause 3 of the same Act. The appeal was rejected as Media Center Officer, Johor Contingent Police Headquarters has seen such offensive comments and cannot be disputed under Evidence Act 1950 that the comments are indeed on Zuliyahia Facebook. Subsequently, through the description of the Head of Enforcement and Investigation Department of the Communications and Multimedia Commissions, the cause of the offensive comments can be traced at RD Resources, where the appellant works. MCMC's findings are not random or blind. The appellants claim that the prosecution failed to prove such offensive comments. The IP address and the timing of the comments were not in line with the entire evidence presented. Having examined the whole case along with the important elements such as the facts of the case and the judgment given, I strongly agree with the appellant's appeal against the conviction and sentence under Section 233 Clause 1 Clause A of the Communications and Multimedia Act 1998 being rejected. This is because the evidence and statements of witnesses have clearly shown that his conduct and actions were intentional. His act of uploading a comment that read, "Sultan of Johor is white like a pigskin," on the social networking site Facebook using the account Zulkifli has indeed been proven to be a mistake with the help of expertise in terms of cyber investigation. Among the strong evidence that cannot be denied its authenticity is that the head of Enforcement and Investigation Department of the Communications and Multimedia Commissions has been able to trace the source of the comments at the appellant's place of work. Among other strong evidence is that the appellant's internet history has shown that he once browsed Facebook Zulkifli. The managing director at the appellant's place of employment has also confirmed that the appellant was one of the officers there on the date of the charge. In addition, all other officers and staff had never used the appellant's desktop computer except for 2 staff members. However, the 2 staff members never used the appellant's computer for the purpose of browsing Facebook except for work. With that, I'm very satisfied and agree with the decision given by the court. That's all from me. Thank you.